Hello, legislation class. This is Professor Opterbeck, and welcome to the online portion of the class for this week. And as you can see in the syllabus and in the casebook, this week we're talking about a set of materials that are called the legal process. And what I want to give you in this lecture is a bit of background into what these legal process materials are. One of the things that I think is really interesting about studying and teaching legislation is that it's really a form of getting at ideas of jurisprudence. In other words, what is law? And what is sort of the role and the function of law in society? And we might say in a legislation class, we're kind of talking about legisprudence, right? What are statutes? And how should statutes be interpreted? But these legal process materials are an important school of American really jurisprudential thought that then relate to this question of how we interpret statutes. Before I talk specifically about the legal process, I want to give a little bit of background of some other means of thinking about jurisprudence that form some of the background for some of the contemporary theories, including the legal process materials that we'll talk about. So one of the deep pieces of background is the notion of natural law. And I think it's probably fair to say that a lot of the modern approaches, including legal process, are really ways of thinking about jurisprudence that are against the backdrop of and often reacting against or responding to historic natural law theories. So natural law, in really broad strokes, would say that there are some unchanging principles for human conduct. These unchanging principles are historically grounded in philosophical or religious or theological views about the good, about God, about reason. So if you look in some of the Greek thought, Greek philosophical thought like Plato, that will adopt kind of natural law approaches, you'll see philosophical notions about the ultimate good and what is right. You look in someone like Aristotle, again, you'll see philosophical notions about what is good and what the purpose is, what the telos of society is. You look in, then in the West, in kind of the Christian West, you look at Augustine, you look at Aquinas, you look at other Christian theological thinkers who developed these Greek ideas and kind of combined them with and mixed them with Christian ideas and biblical ideas. Of course, you have a long tradition of Jewish thought also about law and about the divine command and how that relates to other things, and there's a long Islamic tradition of these things as well. So you've kind of got this historical grounding. The notion within natural law theories of positive law is that positive law should somehow relate to the natural law. And by positive law, what we mean is human law, right? Situated law made by the king or made by a judge or something like that. Now, historic natural law thinkers like, say, Thomas Aquinas, who's within the Christian tradition, one of the great exemplars of really trying to work out a natural law philosophy, would never say that the positive law, the human-made law, could perfectly instantiate, put into practice the natural law. You know, human beings are always living in certain contexts. Things are complicated. The world actually is not always all as it should be, and therefore you might have to make choices between kind of competing principles. And even Aquinas would have said in one time in history you might have one rule that is better, and another time in history you might have another rule that is better, and those rules may contradict each other, but they relate to the specific historical circumstance. But either way, there are these overarching principles, and the goal of the jurist, the goal of the lawmaker, is to try and discern what those overarching principles are and how they might relate to what the positive law should look like in any given circumstance. Now, as I have kind of suggested here, this whole theory is a pre-modern theory. Now, pre-modern doesn't necessarily mean wrong or bad, but it just is a historical marker because it relates to ways of thinking that really are prior to the Enlightenment and prior to modernity. Some of that has to do with general social presuppositions about the role of the divine, of God, or of reason, or things like that. Some of it has to do with the political order, because the political order, the pre-modern political order, is not a democratic political order, broadly speaking. It is not an order that's based on nation states in the way that we understand that today. In fact, Aquinas also wrote a treatise called On Kingship, in which he talks about the proper scope and role and authority of a king. So, there's this sense of kind of authority, there's this sense of how the positive law develops and how it should relate to the natural law. Now, I'm going to give you these things. These are really broad brush historical strokes, and I don't want you to think that, well, okay, everybody was a natural law thinker before modernity, and then, as modernity arrives, everybody shifts. There are different currents of thought, and if you really study jurisprudence, you can see there are non-natural law currents of thought, even in antiquity, and so on. But kind of in a broad strokes, you see after or during the period of the Enlightenment, as the Enlightenment develops, immediately after the Enlightenment, even before that, kind of the development of the notion that it's not really always easy or possible to try and discern what the natural law is, and or that there really is no overarching natural law. So you're trying to think about what law actually is and what role it has and should have in human society and human relationships. In a school of thought that much later really gets defined as formalism, is I think present in the development of the common law from relatively early on. The Anglo common law from relatively early on really had a heyday in 19th century American jurisprudence. So the idea behind formalism is that judges should be deciding cases by applying uncontroversial principles to the facts. All the judge needs are the facts and the law. Politics, morality, other external considerations are considered irrelevant. Some scholars call this a form of legal positivism. Now, in that first bullet, you can see there are some similarities here to natural law. Natural law thinkers would say, okay, there are some principles that are the natural law. Some of those are relatively uncontroversial, like, say, the principle against non-contradiction, or the principle that the good ought to be pursued and evil ought to be avoided. This goes a bit beyond that, quite a bit beyond that, and says within the body of law that has developed, there are some principles that are recognized as relatively uncontroversial within the legal system. You can see here kind of the notion of precedent, right, and of the stability of the law. So when we have this kind of body of principles that is recognized as basically uncontroversial, we can take those principles and apply them to the facts. So a principle that the exercise of dominion creates a right in property, right, would have been thought of as a relatively uncontroversial principle. Of course, there are other principles that might be exceptions and limits and so on. That basic principle, and then we can take some facts and say, was there an exercise of dominion here? If there was, then maybe we have a property right, right? And it's called a kind of positivism, because positivism is the notion that I can analytically look at something and I can kind of dissect it and break it down, and I can come to the correct conclusion based on the analysis that I'm doing. Now, I noted that these categories sort of blend together. It actually can be relatively difficult to distinguish and define even what is natural law, what is formalism, what is the next thing we'll talk about, which is realism. So there are kind of natural law formalisms. I mean, some of these 19th century formalist judges, and even today, judges that have kind of formalist tendencies, might say they're kind of referring to uncontroversial principles that are uncontroversial because they also relate to some sense of natural law. But what you should note is that in formalism, it's not a natural law theory, because the idea is in the actual exercise of doing law itself, of judging itself, we're not taking some external moral principle and saying, you know, I think the moral result would be this. We're taking a settled body of law that's not controversial, and we're saying, given this settled body of law, it should be this. Within formalism, kind of broadly construed, the notion is that judges should not make or change law. Judges really should just apply the law. And judicial opinions really should be kind of taken at face value. When you read a judicial opinion, what seems to be happening in the opinion is the judge is looking at a set of facts, describing a set of settled principles, and then applying it. And in fact, that is what the judge is doing. We'll see in a minute in realist thought, that's not what the realist would say the judge is actually doing. Because of this kind of notion that the judge is really kind of taking things at face value, that we take a judicial opinion at face value, that the judge really is kind of just looking at facts and principles and applying them, sometimes formalism is called mechanical jurisprudence. That it's really just a way of kind of plugging in almost an algorithm and coming up with a decision. Of course, the reality is common law judging is seldom mechanical. There's a lot of considerations that go in. It's not always easy to discern the principles. So there's some pushback in the literature about calling formalism mechanical jurisprudence, but some people say that. In terms of statutory interpretation, a broad theme within formalism would be that statutes are basically to be applied. A statute given to us by a legislature is in itself relatively uncontroversial as a source of law. It is a source of law. It is what it is. And so there's really not much room for interpretation. Interpretation is really just about understanding and applying the words that are used in the statute, and then plugging that in to whatever facts that you have. Now, you'll get a sense, because we've talked about it a little bit in class, kind of the contemporary school of saying, look, judges shouldn't be broadly engaged in interpretation other than just trying to understand what the words mean, and then applying them, is associated with the new textualist school and figures like Justice Scalia and Justice Gorsuch. So some argue that the current new textualists are distinguished from the old formalists. Some argue, and Scalia himself at times suggested, that new textualism is really a kind of sort of formalism. When we talk about new textualism in a week or so, we'll get into that a little bit more, but just sort of hold that as a place marker. And as I mentioned, this kind of thought was really prominent, or arguably prominent, in 19th century jurisprudence. Again, if you really dig into the scholarship, you know, history is complicated. You'll find examples in various places. There's some current scholarship that kind of suggests that the 19th century jurisprudence in the U.S. were sort of a blend of what we call formalists and realists. We don't need to get into that debate. Just for our purpose, understand that this is kind of the backdrop. In contrast to formalism, kind of traditionally in this literature and in this kind of discussion, in contrast to formalism, we talk about legal realism. So what is legal realism? It's a rejection or reaction of formalism. And here, you know, if you hear a law professor like someone like myself or anybody else saying, you know, what this opinion says is they're applying this legal principle settled in the common law to this set of facts. But what's really happening is this judge comes from this political background, or this judge has this economic idea. And the judge could have, you know, come up with 4 or 5 different ways of approaching this case, but the judge selected this way because what's really happening is the judge has a policy agenda, the judge has an economic agenda, the judge has a moral agenda, or something else that's going on. That kind of talk is really realist talk. So judges are not engaged in a deductive exercise of finding principles and applying it to facts. Judges are actually deciding cases based on political or other concerns, and then they justify those choices through whatever legal reasoning that they give us in the opinions. It may be that the judge is doing this intentionally and consciously. It may be that the judge is doing this, you know, not entirely subconsciously in a sense, but if you really drill into it, the realists would say this is actually what's going on. So the notions of statutory interpretation, as you might guess, that come out of a realist school of thought is that, of course, statutes are interpreted. The judges are always bringing, and actually it's appropriate for judges to bring political, economic, or other concerns to bear in the act of interpretation. Right? So you can already see, I think pretty clearly, some of the lines of dispute that we often see in contemporary cases. What are judges doing? Are they applying kind of settled law to the facts, a more formalist kind of approach, or are judges really using this sort of text as kind of a jumping off point for other sorts of choices, a more realist approach? Legal realism is quite prominent in early 20th century U.S. jurisprudence, and there are some important legal thinkers in American jurisprudence like Oliver Wendell Holmes Jr. and others who sort of write about realism, and it becomes kind of in the academic circles and in judicial circles a really important school of thought. It remains a really important school of thought. So just like formalism kind of has its perhaps contemporary iteration in something like the new textualism and in other kinds of new natural law theories and so on, realism has prominent contemporary iterations in the law and economics movement and other related movements. So when you see a judicial opinion that is really making choices about interpretation of a statute or about application of the common law, heavily based on economic reasoning and the economic consequences of one choice or another, and when you see legal scholarship that's really looking at the law and saying, well, you know, what this rule is doing, so you know, in a lot of my classes I talk about law and economics, and I'll talk about torts. You know, what is torts doing? One thing torts is doing, one thing a negligence rule is doing, is it's dealing with the problem of externalities. Right? That's a law and economics move, and it's a legal realist move. Now, I should say I'm not personally a legal realist in philosophy. We can talk more about that as we talk about things in class, although I do think you know, using some of those tools is sort of just an important kind of pragmatic exercise. But a really hardcore law and economics person will say, look, this is what's going on. It's you're just maximizing efficiency and utility and externalities and all those kinds of things. And there are other movements, law and behavioral economics and other movements like that are really indebted to realism. So now you can kind of see this historical context. I really think it's important and useful in a course like legislation or constitutional law, really in any course, but particularly in courses like these, to have a sense of the historical background, because it really does give you a feel for what's going on. So, you know, think about that 19th century formalist school. You're kind of coming out of an era of sort of rationalism, but then through an era of the Civil War and other things like that. The legal realist school, really, you're coming through an era in intellectual circles in which science is becoming very important, and scientific method is starting to be applied to the social sciences, to sociology, what we know today as sociology, and then to what we come to know as political science. So the idea is the natural sciences have broken open all of this, you know, Darwin and so on have broken open all of our understanding of the natural world. Similar principles can kind of break open our understanding of the social world, and those ideas filter into the legal realists who say, look, I can analyze kind of sociologically or economically or politically what a judge is really doing and what the law is really doing. Moving into the 1930s, we have this really critical period for American history and American law of the New Deal. So remember that, you know, the New Deal is this expansion of federal legislation in response to the Great Depression. So the Great Depression is this tremendous economic social crisis. FDR comes into office promising a New Deal for the American people, and this takes the form of economic regulation, of labor regulation, of government infrastructure programs, all of these sorts of things. You'll recall from constitutional law that the federal government's ability to enact these statutes gets challenged. A couple of them early on get struck down by the court. You have then FDR come up with this plan to pack the Supreme Court. That doesn't quite happen, but the makeup of the Supreme Court changes a little bit, and then in relatively short order, the new majority of the Supreme Court begins to uphold this New Deal legislation, really kind of staking out a pretty expansive vision of federal ability to regulate and of the commerce power. So it affects Supreme Court jurisprudence, constitutional jurisprudence, particularly in terms of the federal government, the scope of the federal government's economic power and of the commerce power. It also broadly affects thought about jurisprudence because there comes to be more thinking about law as a form of public policy. So whereas under kind of previous ways of thinking, law might have been thought of as solving, more often thought of as solving discrete problems, there's this increasing move toward thinking of law as solving bigger social problems. Now, of course, if you look historically, I mean, law is very much involved in the question of slavery and of the Civil War. Law is involved in the Gilded Age of the 19th century with the first antitrust statutes. It's not like these ideas didn't exist, but at the level that they come to be thought of, the New Deal is really kind of an important inflection point. There's also a lot of legislative experimentation. So there's a willingness of legislatures, particularly Congress, to sort of tweak things. Say, well, let's try this, right? Let's try and regulate milk prices in this way. Let's try and create a body that's going to regulate transportation costs in this way, things like that. Some scholars talk about this as a period of sort of modified positivism. There's actually an interesting sense. If you see the formalists are really kind of separating the legal rules themselves from morals. Natural law, of course, is connecting moral or philosophical thought ultimately to the positive law, to the legal rules. Formalism is at the level of positive law itself, making some separation there. Positivism is really looking in terms of policy and the way society is structured. This New Deal kind of era is what some scholars call a modified positivism, because you're actually saying, in a way, the moral question, the social question, is more important than the legal rule itself. And really what we're asking is kind of, what's right for society? What do we have to do to get bread on people's tables? Things like that. And that begins to kind of supplant other ways of thinking about jurisprudence. You might say in some ways that there's a rise of pragmatism in this setting, and that's kind of another stream that we just don't have time to really talk much about. Right, so the New Deal era, 1930s, we move into the 1940s, and of course then we move into the era of World War II. Again, obviously a watershed in world history as well as in American history, and it does affect ways of thinking about jurisprudence. One of the big ways that it affects is it sort of ignites a debate about this question of formalism and realism and other ways of natural law and other ways of thinking about law, particularly because of the threat of fascism. So you see people like Hitler and you see people like Mussolini who have a sort of, well, they're dictators, so they have a command theory of law, and they can kind of suspend the law or make the law whatever they want it to be. And you see some American legal scholars saying, look, what they're really doing is taking legal realism to its logical conclusion. Law is just a way of ordering whatever politics it is you want to order, but there's the politics hang in midair. There's nothing saying what those politics ought to be. So if the politics you want are fascism, well, you can construct the law to do that. So you have some important legal thinkers, some important scholars beginning to push back and say, no, we've got to find other ways to ground the law. And this is where the legal process sort of school of thought begins. It begins before World War II, and it really becomes solidified after World War II. So the idea is that we need to think of society as sort of an organic whole comprised of different institutions. So there's an institutionalist, really important institutionalist thread to the legal process thinking. So the legislature is an institution. Government agencies. You know, another piece of what happens during the New Deal is really the rise of the administrative state at the federal level to a really significant degree. So you have these various agencies. You have legislatures. You have agencies. You know, you have the executive. You have corporate market actors. Remember also that a piece of the history that's going on starting in the 19th century is the Industrial Revolution. And then the beginning of the rise of mechanization and the corporation. You have World War II, and after World War II, you actually have what's called the Bretton Woods Arrangement. So at the beginning of the contemporary, or sort of, I guess I would say, pre-today contemporary financial economic system, Keynesian economics and institutions like the General Agreement on Tariffs and Trade, the World Bank, the International Monetary Fund, kind of coordinating the beginning of what we call today globalization. So all of these things, corporate market actors, private associations, all of these are different institutions within society. And what law does in this legal process, and this is why it's process, right? It's about process, not in terms of, you know, civil procedure so much, but the fact that the notion that law really serves this function of coordinating these different institutions within society. That, in this view, is really law's most important role. In this view, law's coordinating function is rationally related to some underlying moral principles. There is a kind of rationalism here. It is not really a natural law school of thought per se. It could be consistent with some kinds of natural law schools of thought, because remember, natural law is going to really have a much more developed, really metaphysical or at least philosophical theory of what the natural law is and where it comes from. Here there's at least some moral principles that law relates to in some kind of rational way. You can see this, for example, in Benjamin Cardozo, obviously one of the famous American jurists, in a text called The Nature of the Judicial Process. So Cardozo says, a judge is not wholly free to innovate at pleasure. He is to draw from consecrated principles. That sounds a lot like natural law thinking, doesn't it? Now, it doesn't mean, again, that there's a worked out theory of natural law, but at least there's some principles or some moral principles that the judge works from in this function of law as coordinating society. And the theory of statutory interpretation that begins to arise out of this is that interpretation is really purposive. And by purposive, what we mean is the job of the interpreter, or the job of the judge in interpreting a statute, is to discern the underlying purpose of the statute. You see an increasing emphasis here then on things like legislative intent and how to discern what legislative intent might be. What is the role of this statute in its coordinating function among these different institutions? And if we can kind of discern that purpose, we have a sort of hermeneutic key to help us understand and apply the statute. Now, the formal kind of term, the legal process, comes out of some teaching materials developed by these legal scholars, Hart and Sachs. I actually have a copy of it here from our library. As you can see, I've been spending some time with it and reading it. Henry Hart and Albert Sachs were professors at Harvard Law School. And a couple of the authors of our casebook, William Eskridge and Philip Fricke, collected these materials and republished them. Interestingly enough, the materials themselves were just mimeographed. They had intended to publish them. They never ended up really publishing them. They used them for many years. They were used in different law schools over the years and became famous kind of for a generation of people before my generation who went to law school. So what they are really comprised of is some introductory materials and then a set of cases and problems. One of the famous problems, and maybe we'll spend a little bit of time talking about this when we meet in class, is the case of the spoiled cantaloupes, for example. So, here you've got this issue of a wholesaler who's buying fresh fruit, buys the fresh fruit, cantaloupes from the grower. The fruit begins to spoil because it has a certain kind of fungus on it that seems to only be possible to arise from the grower. And then there are administrative agencies that are overseeing the kind of the quality of the fruit when it's sold. So it sounds like kind of a mundane, just everyday problem. There are contracts involved, but as we work through it, there's all these different institutions: private ordering, contracts, a regulatory agency, and so on, and the market, right? That the law has to figure out how to coordinate. So these are the materials that get developed and that are kind of mentioned and that underlie some of the opinions that we'll be looking at when we talk about them in class. In the materials, Hart and Sachs say the purpose of the state is to avoid the disintegration of the social order and the consequent destruction of the existing benefits of group living. Notice this sense of social order. Now, you shouldn't think of this in terms of some kind of rigid hierarchical order, right? Remember, they're responding to, and these are among the group of scholars who are responding to the threat of fascism before World War II, and then kind of the rebuilding of the global order, the rebuilding and new building of the global economic and political order after World War II. So the sense is, there is certainly a sense of the importance of freedom within all this, but it's kind of an ordered freedom, right? A very organic view of society as it all fits together. The purpose of law within this, so notice this quote from Hart and Sachs's materials: law is a doing of something, a purposive activity. There's this idea of purposiveness. There's an intent behind it, a continuous striving to solve the basic problems of living. So notice, right? Natural law is referring to some philosophical system, to God or something like that. Formalism, much more granular. Here are some rules, here are some principles, here's how I'm going to apply them to this case. The realists, look, what's really going on is this particular judge with this particular judge's political, economic, other concerns reaching some result. Also pretty granular and even further away from the natural law view. Legal process, look, there's a society here. The society is some kind of organism, some kind of organic whole. It has all these different pieces that have to work together. It's important that all these pieces work together, because if they don't, it starts to disintegrate into something like fascism. We're not going to necessarily get into the broader metaphysical questions about natural law and so on, but we recognize this importance, and law serves this purpose, and we have to understand and read and interpret law in light of this purpose. Process is really central. So here's this quote on process: the alternative to disintegrating resort to violence is the establishment of regularized and peaceable methods of decision. The principle of institutional settlement, notice that word, institutional settlement, phrase, institutional settlement, expresses the judgment that decisions which are the duly arrived at result of duly established procedures ought to be accepted as binding upon the whole society unless and until they are changed. Institutional settlement is an important concept here, right? These different institutions maybe have different interests. These different institutions have different roles. These different institutions have different languages and so on in terms of how they apply things to society. There has to be a settlement, so to speak, a way of pulling these things together so that it holds together organically, kind of like the joints between your fingers sort of thing hold together and doesn't fly apart. Notice also that they do talk about what society ought to accept. So there is a sense of ought. In legal realism, there would not be a sense of ought. In formalism, the sense of ought really derives from, well, here are just the recognized body of legal principles that don't necessarily get referred to some higher moral principle, that question isn't really the issue of legal science. But here there is certainly some kind of connection between the is and the ought. Now, if you've heard that phrase at all, you know, the relation of the is and the ought, this is kind of an important problem in moral philosophy generally, right? And it's one of the critiques and pushbacks in modernity about natural law, because the notion is, well, how can you derive an ought, what we ought to do, from what is? What is may just be random or contingent, or not even something we necessarily want or like. So there's always this question of, really, some would argue you can't derive an ought from an is. And so a lot of the dispute and the question in ethics and moral philosophy, and then relating to jurisprudence, is that correct? To what extent is that correct? You know, and how do we deal with that? And so here's a nice quote from the legal process materials. When the principle of institutional settlement is plainly applicable, we say that the law is thus and so, and brush aside further discussion of what ought to be. So there seems to be a sense, look, institutional settlement has worked. We see what it is. We're not going to then you know, get into speculative metaphysical questions about the ought. But note, yet the is really not an is, but a special kind of ought, a statement that a decision which is duly arrived at as a result of a duly established procedure for making decisions of that kind ought to be accepted as binding on the whole society until it has been changed. Why ought it to be? Because the alternative, they suggest, is that society begins to disintegrate and devolves into violence. One of the really important questions in jurisprudence, and I think it's a question that then filters into our discussion of legisprudence and legislation. Law is historically seen as an alternative to violence. When I start my constitutional law class, I use a quote from Chairman Mao, who says that political power begins at the end of the barrel of a gun, right? Political power, political authority is all about violence. The notion in Western law and jurisprudence, the ideal at least, is, well, no, that doesn't have to be the case. That law actually provides the alternative to violence. A civil legal system, a criminal legal system, institutions, coordination among those institutions is the alternative to mere violence. And this is how the legal process thinkers work that out. Now, what we'll do in class when we meet together, I did say that, you know, in these videos, a lot of times I'll give you black letter law. I realize I did exactly the opposite this week. I gave you a lot of theory because I think it's important for you to situate where all this stuff kind of resides. We will go through the cases that we have, the primary cases. And what we'll try to do is tease out why did our casebook authors give us these cases as examples of legal process materials, and then talk a little bit more about what we think about the different alternatives that we've looked at so far, you know, natural law, formalism, realism, legal process. Again, I don't want to leave you in this lecture with the thought that, well, this is all there is and these are the current schools. Legal process really went through a pretty significant decline in the 60s and 70s. We'll talk a little bit more about that in future classes. You can imagine why, right? It's the 60s and it's the rise of critical legal scholarship, which really radically questions everything that's gone before. But then arguably, elements of legal process thought kind of undergo a bit of a renaissance, and elements of formalism kind of undergo a bit of a renaissance and remain with us in some of the differences that we see today, which we'll end up getting to. So that's the end of the online portion of the course for this week, and I look forward to seeing you in class on Thursday and seeing how some of these different ideas work out in some of the cases and materials that we have in the casebook.